G'day, Kim. How are
Hey,
you?
I'm good, Andrew.
You're looking relaxed.
Oh, these things come around so quickly, though, don't they?
They do.
A week goes
Nina,
past.
come home.
You've never worked so hard, have you?
I've never worked so hard. God, she's killed me.
Now you know how much she does.
I know how much she does, and if you're out there listening, which I doubt,
No, she won't be.
we miss you.
Yeah.
Look, today there's a couple of things before we get going. Yesterday was Anzac Day, and you and I both worked through it. I took the girls to the dawn service, which was fun.
Yeah.
It was moving. Both of them really got it. Both of them strangely said, Australian people died. That's just terrible.
Mm.
And as I explained the circumstance of why they died, they were horrified that, as a result of our colonial power dumping us on the wrong beach, people died.
Mm.
But I think it's a really important day to remember for all our service people. And that was part of the fun conversation, was saying, I'm employed.
Mm.
Soldiers serve.
Yeah.
Different thing.
Big difference.
Yeah, I might put my money at risk. I might put my brain at risk, but these people put their life at risk.
Yeah.
And the girls really got it.
Mm.
And so when we talk about public holidays, this is one that I think is really important.
Yeah.
Not so much Melbourne Cup and AFL Grand Final, but I just don't understand why we have it on Thursday or Melbourne Cup on Tuesday, because we know there's going to be this massive productivity shortfall that follows it.
Yeah.
Now, I'm very proud of our staff because they're nearly all here today, which is wonderful. But as I went into the car park, there were no cars.
Yeah. Had a dream run in. It can be a killer for business, though, and it annoys the hell out of me, I've got to say, when people refer to it as the Melbourne Cup weekend.
Yeah.
It's not a weekend.
No.
It's one day.
So look, I want to raise that because I think we forget that what keeps the world going is people paying taxes, and that's created through business.
Yeah.
And I think things like Anzac Day are wonderful things that we should remember in so many different ways. My memories are a bit poisoned because of family who died and because of what the British did. So I'll have a resentful feeling for the rest of my life about it. But I also feel for every service person who's ever been injured or died. And I really value the fact that people do serve for us, put their life on the line. I think that's amazing, and we should celebrate it. But I can't find a good reason why we can't celebrate on a Friday or mourn on a Friday, why we have to break up a business week and then know that we're going to have this massive fall in productivity. It's like stealing from ourselves. Anyway, look, that's my rant for the day. I'm sorry about that.
Well, it does just fall on that day, though, the 24th. So there's no avoiding. You can't make it a Friday. But I know what you mean.
Yeah. Well, look, I'm not so sure about that, is my point about it. We get caught up in holding to a particular day, like, the day in which it is Australia Day, which I don't like either, by the way. But whatever it is, does have to be that. What changes it if we say, well, look, we're always going to do this on a Friday. Why don't we make a Friday the day rather than a specific day? It's sort of a nonsense that's accrued over time where people want to hold on to something but don't understand the cost of what they're doing. Anyway, that's me. Look, the other thing is what I've done, Kim.
Not like us to be that controversial.
Yeah. Oh, no, it offends me. And it offends me as a business owner. It offends my clients who are business owners. And yet it is the business owners of the world who keep the economy going. And people continue to punctuate weeks with holidays with gaps in between. Everyone takes the gaps because that's human nature. And yet we have this massive drop in productivity. We see it every week, every time it happens. It's crazy. Look, the other thing is I've got a few cases for you, Kim. And the idea of these cases is not the usual thing, which is to tell you about a decision that has been made, which is important. It's really to look at the processes that sit around people's behaviour when they're in trouble and what could have been done to prevent it. So we'll go later to a Shane Hill case, which shows a really good way of quarantining risk, okay? But what I wanted to do was start first with Wynn's case, which is a defamation case. Now, defamation, in the last 6 months, I've had 6 to 7 matters where employees have either done things which defame or who are contemplating defamation proceedings. 10 years ago, it was never part of who we were, okay? Now, defamation has 3 primary defences: justification, which is truth or partial truth, changes a bit in jurisdictions. It then has fairness of comment, which relates to public figures. You can't be out there saying things and not expect people to make comment about it, as long as it's not malicious and damaging. And the last one is privilege, something that's said in a court or set of part of a proceeding which has either absolute or qualified privilege. So they're the three defences, and the ones we see, like the Ben Roberts-Smith's one, was a justification, and why he ran a case that the chance of it being proved on the balance of probabilities he did it, you just have to wonder who was really driving that case, because it was madness.
Yeah.
And we saw the same thing in the Lehman. I'll come back to it. But in Wynn's case, this was the dean and professor of Edith Cowan University. The age, and what backs the age, printed a number of different jurisdictions, suggestion that she created a toxic workplace and harmed people.
Yeah.
And then when they got along to court to prove their substantial truth, their justification argument, they didn't have the facts. They didn't have the things that would say that people were harmed by this or this did occur. So when you go to court, you've got to not only give evidence of your defence, you've got to identify each element of that defence and have specific facts that you can prove.
Yeah.
And when they got in front of the judge, it's not the final hearing, but the judge said, look, this is tenuous. You've got to think about this seriously. If you go with this, I'll strike it out. So come back and have a shot at it. But my point about this is, this was something where Fairfax thought this is a really interesting, juicy thing to run, and didn't understand it was going to blow up on them. Okay, they've destroyed someone's life in the process of doing this. Person's resigned and done all that terrible stuff. We just remember, when you gossip about people, the harm you can do.
Yeah.
But the Lehman legacy is this. You go in and fight for something and support something like Channel 7 did, and you open your own back door. And what we saw in Lehman is it isn't only Lehman who fell to the ground without his hat. It was Channel 7.
Yeah.
And it was a slaughter inside Channel 7. In all our businesses, we have a back door. There's some things we do which are not flash. We don't mean to do them, but you never really want that laundry to be ventilated. Bring a defamation claim, or be the subject of a defamation claim and not resolve it in a sensible way, your back door is open.
You can blow up your whole culture.
That's exactly right. And that's what happened in Channel 7. And it will damage them financially, much more than just the cost of proceedings. It will damage their ratings for a long time. So I guess, why am I saying this to you? All you have to do is shut up. You know, when you're terminating someone, when you're dealing with someone for misconduct, you don't have to tell the world.
No.
We've been dealing with just recently ourselves. You know, what do you say? Well, you don't.
No.
You step out behind the person you've terminated and say, you know, so-and-so has left, or if they've terminated, that you're candid but concise about what you do. But being loose opens your back door. And that's the Lehman legacy, is that the moment you start these things, you have no control where they go. And if vested parties start to put money in to make that broader, it can destroy you. And that can be anyone. Well, look, let's go on, because I want to go to Heel, because Heel is a case which, God, I love watching this guy play basketball, by the way. I remember him playing. He was subject to investigation based on bullying. Senior players came forward, management said, look, he's a bully, we're unhappy with what he's doing. They start an investigation. Now, the really good part about this is the club carefully quarantined the process. So all the things that Shane Heel said were being done for, all the reasons that he alleged in a general protection sense, the workplace rights, not known by decision makers. So when the decision makers went to proceed in this process, it was clean. So once he got to court, again, not the final determination of it, but when he got to court, they said, no, I don't see these workplace rights you're talking about. All I can see is investigation undertaken because of complaints that were being made. There's no exercise of workplace rights in that. So a perfect process, Kim.
Yeah, it was.
And now, do you see what I mean? Here we are. This is the second matter we're talking about where there isn't a final determination, but where they got it right. So let's swing on to our third case, okay? All right.
Now, I didn't really need to rock up today.
No, you didn't. No, I'm in a bit of a roll today, actually.
I'll just sit here and relax.
No, it's okay. Well, I'll throw to you shortly. This is a case really about consecutive fixed contracts. Our Fair Work commissioners never liked them. I just want to be clear about that. But these were genuine. They're accepted in an organisation where Volunteer Marine Rescue is a sort of devolved government entity in a way, and therefore there's only funding for roles. So it works.
Yeah.
So in places,
when the role's dependent on funding,
it works.
it works.
But with this guy, there were some things that changed. Kim, over to you.
Okay, so he was coming up to the end of his third fixed-term contract. He was investigated for misconduct. It wasn't substantiated. It just turned out that there was tension between him and his manager.
Now that's the really big issue, isn't
Yeah.
it? So at this stage, there has been a finding in an investigation, no wrong. And then what happened?
And then they terminate his employment 2 weeks before the end of the term. But the court could demonstrate there was an expectation that the role would continue, and the company did get funding, and then they advertised his role on Seek. So it wasn't unfair.
And they delayed the whole process rather than dealing with it when they should have dealt with it. So it was all about terminating it. So this was a jurisdictional argument, okay? And that's the really important. This was, does this person have a claim? And what the commissioner said is, yeah, and I'm going to do a conciliation with you, and let's see if you wake up to yourself, because there's not a lot of loss that's been suffered.
Yeah.
But he may get 6 months. Because that would be part of the next term for which he was entitled for. So again, can you see the mistake that's been made here? I mean, Kim can see the mistake. Here is a case where someone formed a view they didn't want someone and tried to use a method that they thought was permitted to try and do it. So this is like terminating someone for redundancy when you're unhappy with performance, which repeatedly gets a smack across the chops.
Just performance management.
Yeah, if you've got a problem, deal with their performance. But they didn't have a problem, they didn't like him. That's the real problem. Yeah. Okay, so let's swing to our next case.
Oh, I love this case. This is so funny.
Okay. Now, Kim, talk about this. This is my final dumb case of the week, okay? And this is actually an employee being dumb. So it's a nice change.
Employee being very dumb. He was terminated. He was very clearly terminated.
Had to return his
property, everything. The only issue was there was a payroll error, so it was 2 months before he received his notice period. So he's thought, oh, beauty, I'll go and argue that I was put on gardening leave for that 2-month period and try and get an extra 2 months' wages.
Yeah.
Dumb argument.
Dumb argument.
All the evidence pointed to the fact that he was very clearly terminated.
Yeah. And can we all remember, we might not like the commissioner we get or the deputy president we get. That happens to us now and again. But the answer is, after a few months in the job, their politics are inclined to fall aside and they just become officers of the court. And what they all are, because they come from a practical experience background, is they pick bullshit and they deal with it in a real backhanded way and very quickly. And this is a case where you actually, as you're reading the last couple of paragraphs of the judgment, there's almost contempt in the commissioner's voice, which is unheard. But we've seen a number of cases where people have tried to do things that are half smart. You know, the case before, use the fixed term contract here. I got paid late, therefore I was really continued employment. It just doesn't run. No. These are experienced, clever people supervising work they know well. And when they see it, they go, it's just not right. No. So there's another not right.
It's just about doing the right thing at the end of the day.
And that's workplace. We've said 100 times, probably more now because we've done more than 100 episodes, that workplace law is a moral place. You be good and good things happen.
Yeah, exactly.
Now, being good includes process and having good process for workers' compensation, for unfair dismissal, all those things. But at the end of the day, being good creates a great workplace.
Yeah, it's quite simple.
So why wouldn't you do it? Why would you try and be, as my dad would say, too smart by half?
Yeah.
It's dumb, isn't it? All right, well, let's get on. We're getting close to the main topic, and this is just a new case that came out of Geelong. This is another forklift incident. This was picking up a bin of stylage, and I'm not sure whether it caused death or serious injury. I can't remember. It was reported in the Herald Sun. So death. It was very hard to get any facts. We couldn't find out much online. The guy involved, Gorman, has been committed for trial in the county court on reckless endangerment. I guess I wanted to raise this because whenever you see motorised plant now and there has been serious injury or death, the charges are not breached of primary duty. And the reason why is that it is a notorious fact that mobile plant without proper traffic management is something which you knew. So you get past the subject. So reckless endangerment has subjective, objective test. Do you know there is a risk? Well, every person knows with a forklift, if you don't actually confine its area so it's excluded, you can cause serious injury or death. So they're arguing, and they lost, the solicitors lost, that you couldn't prove the subjective element. A blind horse could work out which direction this was going to go in. And objectively, knowing that, what were the actions that you took, or were you careless towards that? Well, here there is nothing objective to defend it at all. This poor bugger's in a lot of trouble. But subjectively, they were never going to defeat the subjective, because the moment you have a forklift, you see it with two big things coming out like this. It's motorised. It can hurt. So good start to where we go onto the main topic, isn't it? So let's swing on to our main topic. And we did this because we've had a number of our clients who have had some pretty unfortunate incidents in the last year. When I look at the 20 or so matters we've dealt with where there's been serious injury or death that have come to the business, these are the things that you and I see every day. They mostly involve motorised plant or fall from heights. Even the chain incident where a chain fell down, it fell down off a crane for the industrial manslaughter cases. But if we talk about where liability falls for industrial manslaughter now, what the courts and the regulators are saying clearly is there are 2 or 3 known major risks in any building, in any place of work. They are where there is motorised equipment working, whether that is a truck, a forklift, a crane. Whether that worksite is a building or open space. Everyone knows that something with a motor can't stop. And if it hits you, it will hurt you. Okay? Now, the regulators are saying we're not going to put up with it anymore. We've been charging primary duties all over the place for years and years, and yet the rate of incidents around forklifts are growing to the extent that there are a number of aircraft manufacturers and people now who have created production lines that don't have forklifts involved at all to try and stop the use of motorised plant. But the other one which has taken off is falling from heights. We've seen there's a total of 13 industrial manslaughter charges, I think, throughout the states and territories. I just want you to hear that number again. But anyway, it's a lot, and we've probably had 50 or 60 reckless endangerment. 5 years ago, A, there wasn't industrial manslaughter, and B, there was only one charge of reckless endangerment 5 years ago. And now look at what we've got. We've got somebody serving 18 months jail with a 5-year sentence. The world has changed. So if you have a void or a place someone is working which is above 2 metres off the ground, you've got a duty of care. You know clearly what that duty is. It's actually defined in the regulations as to what it is. You can't escape the fact of that duty. And anything that was so neglectful to allow someone to fall is seen by both regulators and courts as such a serious breach of duty. Because when you see someone standing up and they could fall down, how could you let it happen?
Oh, I hate it when I see it.
Yeah.
And you see it all the time.
Well, we see it domestically, don't we?
Yeah.
I commonly, as I'll drive on a Saturday or Sunday, I'll see people my age, not young, climbing up ladders unsupported onto roofs without any method of support. But the fact is, regulators won't tolerate it anymore. So nearly all but one of the charges laid related to motorised plant in some or falling from heights. What we are going to see change, and it's starting to come through. So we've started to see with the Victorian Building Authority a reckless endangerment charge around managing performance poorly and restructure. We are going to see an egregious breach of a psychological hazard, and Victoria particularly will prosecute it. And I think, to be candid with you, so will Queensland. Because Queensland's been quite an aggressive prosecutor as well and has a much more restrictive code and set of regulations there. But if we see someone die as a result of sexual harassment or bullying, I guarantee you in the next year we will see an industrial workplace manslaughter charge laid, because the death will most likely not be at work, and that's exactly what industrial manslaughter is designed to capture, is where the injury arises to death outside of the workplace because of the psychological hazard in the workplace. So look, we thought we'd just spend a bit of time because it's worthwhile to say, well, if I had $100 to spend on safety, where would I spend it now? Motorised plant, fall from heights. I would be meticulous about it, absolutely meticulous. If I had an extra $100 about where I was going to spend it in the future, it would be about getting rid of the really egregiously bad psychological hazards, because they still reflect 80% of compensation claims, sexual harassment and bullying.
Yeah.
Now, if you do those things, you're not going to jail. Just those things, you're not going to go to jail. So I hope that helps a little bit.
Well, tell you what, it is so worth the investment, and they're relatively simple measures. There are so many consultants. If anyone needs a safety consultant, we can certainly put you in touch with people.
Yeah.
Just to assess your operations and make it safer.
Yeah, and
it's
so
not
look,
hard.
Same with with HR or safety. Talk to us at the Found Group, and they'll come and do the high level audit, which says, look, these are your really high order risks. It's not going to cost you $50,000. It doesn't take long to identify high order risks. And as you say, creating a proper exclusion area is not hard.
No.
Preventing people from falling from heights, it's not hard. But it does require supervision in both occasions, because that's the heart of it.
Yeah.
Without supervision, people breach the rules, which create the fatalities. Well, let's go on to our problem, which is again longer than I meant it to be. I didn't mean it to be. I thought it was short. Okay, off you go, Kim. You read the first two paragraphs, send us up to me.
All right. Donald?
Yeah, Donald.
Donald Trump. Donald was the managing director and the sole owner of Stampede, a processor of horse manure for domestic gardens. Stampede had a plant that liquefied the manure, then processed it into hardened balls for ease of consumption in the domestic gardening market. Consumption. It's one word you could use. Anyway, sorry. The plant was situated in Camberwell and had warehousing facilities adjacent. When the hardened balls were produced, they were packed into 10 kilo and 20 kilo bags, then racked in the warehouse to meet orders. WorkSafe had attended the site 3 times in 2023, each time issuing improvement notices around traffic management, particularly the failure to prevent pedestrian access into what was a busy warehouse, the absence of a traffic management system, and subsequently the failure to follow the plan. On each occasion WorkSafe attended, Donald shot out the back door and allowed Buzz Cauldron, the operations manager, to take the rap. But Buzz was pretty grounded and always told WorkSafe the truth. Following the 3rd occasion, when improvement and prohibition notices were issued, they stopped the use of the warehouse until mechanical barriers were introduced.
I'll take over. This was to lock out employees due to the repeated failure of all, including Donald, to follow the plan, and CCTV evidence was damning. WorkSafe required physical barriers because of the culture of non-compliance. Donald gave Buzz a final warning for his part in providing evidence to WorkSafe, which led to the notices. 2 weeks later, the maintenance crew disabled the lockout mechanism to permit stock taking to occur on 30 June to settle the yearly accounts, which means people could actually get into the area. The direction to disable the lockout came from Donald, who issued a brief message saying everyone must respect the 3-metre exclusion rule whilst the lockout was down. Buzz knew that disabling the lockouts was dangerous, as the forklift drivers were proud of the speed they picked and loaded. The forklifts had no speed governor. You know, on most forklifts, there is a governor that prevents you going over 10 kilometres an hour. He complained to Donald, who made it clear he didn't want Buzz causing trouble. This was business, just make it work. The forklifts and their drivers were owned and employed by Fastpack, a commercial contractor. The coordination plan between Fastpack and Stampede had not been updated since 2014 and gave Fastpack exclusive management control of the warehouse. Since that time, there had always been staff members of Stampede in the warehouse assisting with truck loading and unloading. The supervisor of the forklift crew was called Prue. She was an employee of Fastpack. She was aware of the disabling of the lockouts and advised her employees that people will be entering their space and make sure the 3-metre rule is adhered to. Fastpack had no policy of their own, relying on Stampede's rules and coordination plan. Prue did not consult with Stampede, nor did Stampede seek to consult. It simply advised Fastpack 12 hours before the disabling of the lockouts. Mike Spent, second in charge under Donald, entered the warehouse at 11 p.m. to see how the stock take was doing. He entered by the side door where a bank of fluorescent lights connected to the same circuit as the lockout devices had accidentally been shut down. He emerged through the darkness and was struck by a forklift driving forward at well over 25 kilometres an hour. The maximum speed under Stampede policies and coordination plan was 10 kilometres. With an elevated load 2 pallets high carrying 20 kilogram bags of manure balls. This was a direct breach of the golden rule and about never driving forward with an elevated load except in the immediate vicinity of the truck when loading. Mike suffered major degloving injuries, stripping skin from arms and legs. He died shortly after of uncontrolled blood loss. All right, so question 1. Donald caused an investigation to be undertaken. As a result of the investigation carried out by his son-in-law, who owned an OHS business nicknamed Jarhead, could be Jared, Buzz was summarily dismissed. The finding by Jarhead is Buzz permitted Fastpack to drive quickly and failed to undertake a risk assessment of the environment without lockouts in place. Assuming Buzz didn't undertake the risk assessment, was there a valid reason for termination? All right, let's just step back a little bit. Buzz has raised his complaints. He said it's not safe. Yes, he should have undertaken a risk assessment. There was no consultation between him and Prue, nor Prue and them. And when there is a change in process in a coordinated space, there must be reconsultation and a re-agitation of what is the risk process. So yes, Buzz is in trouble, but the courts would not be too interested in Buzz.
No.
They'd be much more interested in Prue, the contractor, Donald, and Tampede. So yes, a risk assessment should have been undertaken, but it is the smallest vice out of all in this whole process. The contractor management piece is appalling, and the fact that you give someone exclusive control sounds good under a contract. But when you don't have a proper supervisor, a real safety supervisor, the contractor is you. So there's been no carve out of liability. So the liability sits with Tampede. There is direct responsibility for Prue, who's providing the supervision, and should have stopped work at the time lights weren't available when people could come in. So there's a whole lot of problems here. Buzz is in a little bit of trouble. He might cop a Section 25 breach. Okay. But he's not going to be the big bearer of bad news. Would Buzz have any defence and cause of action arising out of his dismissal? Well, let's just go through the ones he's got because they're beauties. For a start, when he got the first warning for raising a safety issue with WorkSafe, it's a clear breach of the discrimination provisions under the safety law in all jurisdictions. That's a significant penalty. His termination now under these reasons, again, he raised the complaint. He has both general protections and discrimination claims. He has a good cause of action. Okay, let's go to the second question.
Can I read something?
Yeah, you can read something.
As the warehouse was under the exclusive management and control of Fastpack, could Tampede and its employees and officers be charged? If so, what for? And does the contract relationship carve out liability for Tampede?
So the answer is, let's go to the second question first.
Okay.
To carve it out, you've got to demonstrate that the organisation had policies and procedures that fitted with its area of expertise. They didn't. So they're gone. So there is no carve out. Secondly, they had to demonstrate safety competence. They didn't. So Tampede is liable, but it doesn't change the liability that also sits with the contractor on site. So, but Tampede can't escape. That's the thing. You're going to have full liability for two parties. It's not a zero-sum game. So if we look at that, the first thing is, what can they be charged with? I think Donald's running down the path towards certainly a reckless endangerment charge, and the business in this circumstances could face an industrial or workplace manslaughter charge because of the duties that exist. Donald's far enough away he may not be drawn in, but they'd certainly charge him with industrial manslaughter or Victoria workplace manslaughter to get the leverage to at least get a charge that sticks and plea guilty for reckless endangerment. As I said, I don't think Buzz is in a lot of trouble. Okay, could Fastpack and Prue be charged with any OHS offences? And if so, what? Same thing. I think Fastpack is staring down the barrel at a workplace manslaughter charge. Okay, Prue, not enough skills, not enough insight. She'd get reckless endangerment. Still change, off to jail for that. Not good, is it? What charges do you think that Donald, Buzz and Tampede will face, if any? Well, we've talked about those. Okay, so I think if I was the regulator, I don't like Donald in this one, but his behaviour would come out and be shown for what it is. The fact that he did issue a direction around the exclusion will probably drop it down to reckless endangerment, but his knowledge of the failings in the past, his personal knowledge, may be the bit that tips it back to workplace manslaughter.
I think it's worth making the point that we get inquiries from owners of businesses, but who contract out, and they say, well, we've got contractors, so they're responsible for safety. We're not. And that's a major misapprehension.
because that's right. The principle, the employer is always liable until they can demonstrate those elements that I've talked about, which is safety competence, safety supervision, and a system of safety, which is regularly audited through a supervision of systems to demonstrate you've carved out that liability. In other words, you've got someone else who will do everything that's reasonably practicable. Where you have a knowledge that's not the case, you're on liability, and your obligation is to supervise the job come back, not just supervise the systems. Well, I reckon that pulls us up, I don't think there's another question. Is there another question there? No, it's just us. So look, can you give us a bit of a thumbs up? Bit of fun this week in some ways, but I hope what we've done is given you an insight as to the big race, the safety risks coming towards you, but currently what are the biggest safety risks, and to understand people are being charged right now with industrial manslaughter. It's not like it's going to happen. It's happened. And we've already got reckless endangerment charges going towards psychological hazards, and that is where it's going to go in the future. So great to have you along again.
Good to see you.
Yeah. Nina! Have a lovely wedding and everything else, Nina. See you later, and see you same time next week. Bye-bye.
Bye.